Good evening, Dr. Hadelina. Let me introduce the Old V Capital Insurance Services Limited 2017 UK SC24. This commercial law case prompted the Supreme Court to resist the principles of contractual interpretation. It considered the balance between contextualism, the commercial context in which the clause was drafted, and the textualism, the literal meaning of the clause. This had two major precedents. Arnold v. Britain 2050 UK SC 36 and Rainy Sky SAV Cockmin Bank 2011 UK SC 15. In Arnold v. Britain, the court prioritized textualism, whereas in Rainy Sky SAV Cockmin Bank, the Court preferred a commercial common sense approach towards interpreting contractual ambiguities. In Old V Capital Insurance Services, the Supreme Court contemplated competing interpretations of an opaque determinative clause in the sale and purchase agreement for an insurance broker. The purchaser capital bought a car insurance company and was in respect of losses derived from the mis-selling or suspected mis-selling of insurance products prior to the sale, or warranty claims made within 2 years. Upon discovering that the company had potentially mis-sold insurance to customers, it reported this to the Financial Services Authority, which imposed a remediation scheme upon the purchaser to compensate customers. This led to Capital incurring a loss of approximately 1.35 million. The purchaser argued that this loss fell within the scope of the indemnity clause. The sellers proposed that as there had not been any complaints or claims made against the company and the losses incurred were due to self-reporting, the indemnity clause did not apply. The Supreme Court upheld the Court of Appeal decision in favoring the seller's narrow interpretation of the contract. In doing so, it considered the commercial context in which the buyers had an interest in securing a broad indemnity clause, whereas the sellers had an interest in acquiring a narrow one. It was examined the language of the contract which favored the sellers. The Supreme Court arrived at the view that textualism and contextualism are not conflicting paradigms, but rather tools to interpret the language within contracts. This affirmed that the balance needs to be struck between the two, as contractual interpretation is a unitary procedure. Hence, the decisions in Arnold v. Britain and Rainy Sky SAV Kakmin Bank are not at odds. The case considered the interpretation of an indemnity clause in a sale and purchase agreement for an insurance broker. The purchaser was indemnified for loss suffered as a result of claims or complaints for mis-selling registered with the Financial Service Regulator. However, the court noted it was still necessary to place the clause in its contractual context and to consider the wider factual metric. The parties to the contract were commercially sophisticated. In addition to the contractual indemnity covering loss from mis-selling, the seller had also given details warranties as to regulatory compliance. These warranties may have enabled the purchaser to recover for its loss. But for the expired 2-year contractual limitation period on warranty claims, the court held it was not contrary to business common sense for the parties to agree wide-ranging but time-limited warranties, with the protection of the further indemnity unrestricted as to time, but triggered in more limited circumstances. The court would not improve the bargain for the purchaser. So that's all for my video. Thank you.